You'll miss me taking care of you,
I know
girl.
it. I know it. You get back.
Oh,
Okay. Okay, good. Hey, Jack.
hello.
I wish I knew how to click the email coming
Oh.
through.
Yeah, you know.
The nails look good. I'm gonna,
They need
I need to go get my toast
I've got
again.
all these paper cuts from opening up all these ballots.
You need to take some time off.
I'm
after all
going
this
to
over.
after.
Hey, Tab, can you add our treasurer, Shay Champ?
I'm sorry, I've got a dog fight going on. Give me just a second.
Okay. Dog fight.
Okay, who did you need me to add?
Shay Champ, I think it's SCHAMP at clarkscoky.com. If not, then it's Clark County Treasurer.
I'm sorry, I still didn't hear. What's the name?
Her name is Shay Champ, and I think the
Okay,
email
I
would
see her.
be, okay. So we have me, Joe, Greg, Chris. We're missing Daniel, Robert, and Travis.
I'm here.
There's Travis.
I'm here.
Oh, okay, there's Robert. So Daniel is missing. And there he is. Okay. I have 6:30, so I would like to ask you all to join me in a brief historical prayer borrowed from the words of Franklin Graham at the 2001 inauguration of George W. Bush. Lord, we pray that you'll help bring our country together so that we may rise above politics and seek the larger vision of your will. Use us to bring reconciliation between the races, healing to political wounds, that we may truly become one nation under God. Give us calmness in the face of storms, encouragement in the face of frustration, and humility in the face of success. Give us the wisdom to know and to do what is right, and the courage to say no to all that is contrary to your statutes of holy law. Amen.
Amen.
Now the pledge. I pledge allegiance to the flag of the United States of America, and to the republic
for which it stands, one nation, under God, indivisible, liberty, and justice for all.
Hey, Judge,
Ma'am?
what about David Perdue? He's supposed to be on.
I'm here.
Okay, there he is. I couldn't see you, David. I didn't want to start without you.
Not a problem. I'm just trying to be quiet.
Okay, I will now call the meeting to order and ask the clerk to read the roll.
Magistrate Davis,
Present.
Clinton,
Here.
Graham,
Present.
Constantopoulos,
Present.
Thompson.
Here.
Who am I missing? I can't see you all, so I don't know who I'm missing.
I'm present, Michelle.
Oh, and Elkins. There you go.
I'm here.
Thank you.
I'm here, Michelle.
Oh, and Judge.
I think that's all of us. You should have in front of you a copy of the agenda. Do I have a motion to adopt the agenda?
So moved.
Motion by Magistrate Davis. Is there a second?
I'll second Magistrate Elkins.
Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Item number 6, discussion regarding a proposed ordinance for solar energy in Clark County and consideration of resolution to propose a text amendment to the Planning and Zoning Commission. First, under this item, we have the Honorable John P. Rumpf of White, McCann, and Stewart.
Thank you, Judge Pace, and thank you to the court for allowing me to be here. I hope each of you maybe saw the letter that we wrote to the court, to Judge Pace, kind of summarizing the process of where things currently stand with regards to a solar development in Clark County. We represent a developer who first approached the Planning and Zoning Office last fall, and we've kind of been involved in a collaborative process with the Planning and Zoning Office, Judge Pace's office, the county attorney, the city manager's office, industrial authority, since the early part of this year, through a number of kind of Zoom meetings such as this one, to develop a path forward for solar development within Clark County. Most of you are probably aware that the current zoning ordinance does not mention solar power. And at the advice of kind of the planning office, we've been working on a draft solar ordinance that would allow for solar development within the community. That draft ordinance was done in conjunction with the county attorney's office, the city attorney's office, the planning and zoning attorney's office. And we've come up with a draft ordinance that has now been discussed twice by planning and zoning. And I think prudently, they've asked for some input from the legislative bodies as to what the interest is of our community to adopt such an ordinance. And so they've kind of put the ball into your all's court. Our local planning ordinance allows a map amendment or a text amendment to originate either with the legislative bodies or with the planning and zoning itself. And planning and zoning is indicating wanting to know kind of where this body stands in terms of a proposed ordinance before it moves forward. So I did include in that letter a copy of the draft ordinance. We've worked in conjunction with, again, a developer that has a lot of experience with this nationwide. We're joined by another developer here tonight who also has a lot of experience with that. And we've been approached by a number of folks who are landowners in the community who have been approached by the two developers that are represented, but also some other folks who are interested in this as a potential opportunity for our community. Obviously, this is the very preliminary stage. What we're asking is for the court to kind of give some direction through their proposed resolution to the Planning and Zoning Commission to take this matter up. I think in my communications, there's been some delay. Obviously, we're living in a unique time with COVID, but we would just ask that this move forward, understanding that this is the very preliminary stage. There'll be, before it could ever be a reality in Clark County, it would have to be considered twice by this board, but also by the city commission. So there'll be a lot of time for community input. And again, what's in front of you is just a very preliminary draft done in conjunction with the city officials and the county officials who have the responsibility to kind of guide development within the community. So I want to be brief. If you have specific questions, I'm happy to answer them. In terms of economic development, this does provide an opportunity to increase both real property tax base. Most of this ordinance is aimed at agricultural land. Obviously, if those properties are used for commercial purposes, they're no longer going to receive an agricultural exemption for real property tax purposes, but it also will increase personal property taxes. All of this equipment would be taxed as a personal property tax. And also, obviously, there'll be some new jobs and new construction and economic development to the local community that comes with that. So I think it is an opportunity for some economic development, but also increasing our tax base. And I'm happy to answer any questions. Again, I do represent an entity with a specific development in mind, but there are a lot of folks in the community interested in bringing this forward.
So when you speak about the tax base, Mr. Rumpf, can you tell me what the approximate tax impact a change of this sort would be on a particular property, perhaps per acre? Do you know that?
Sure, I can kind of break it down for you to a certain extent. Kind of for simplicity's sake, obviously the real property tax will be based upon whatever the fair market value of the property is. So once you all set a tax rate, whatever the purchase price is for that property, if it's a sale The real property tax will be based on that. In terms of the personal property taxes, the Department of Revenue has currently set those figures, and the way we've kind of calculated for the purpose of an example is if you had a 100 megawatt facility in Clark County, and that's a large scale commercial operation, that would up to $500,000 increase in personal property revenue taxes annually. And that's going to assume there's no economic incentives at all. And about 190,000 of that, just based on current calculations, would flow to the school system. That's the personal property tax. On top of that, you obviously have, any of these facilities have to have full-time employees on a limited basis that obviously will contribute to payroll taxes and things of that nature. So I think for a 100 megawatt facility, that's kind of the, probably the minimal size that you would have for a commercial grade solar facility. That's the kind of tax base you're looking at.
John, Robert Blanton.
Yes, sir.
100 megawatts is equal to about how many acres?
It varies. Right now, you can get about 5 to 7 megawatts per acre, but that's going to vary. I mean, this technology is constantly improving. So, the capacities depend really on how the technologies will continue to improve over the life of the, over the operations. These operations tend to have right now 30-year shelf life at a minimum. So you're looking at, obviously a lot of opportunity for development and technology over the course of that period of time.
Typically, what's the optimal size for a solar farm? Too big, too small? What would be the optimal size?
A lot of that has to do with transmission line capability. So, the transmission lines that run through Clark County have a capacity, and once that capacity is met, there's no further capacity. So it really, I'm not trying to be coy, Mr. Blanton. It depends. I would think that they want to be 100 megawatts minimum, and the reason for that is obviously there's efficiency and scale. So the larger they are, obviously the more efficiency there is, but there's also a need to there's a limited amount of capacity on the transmission line. So the optimal size, I think, differs from community to community, but I would think in Clark County it would want to be at least 100 megawatts.
So typically, how many employees would there be in the building stage, and then how many employees would there be in the maintenance stage after that?
And again, that does vary from, from project to project. The project in Lyon County was an 86 megawatt facility, and they employed about 400 construction hires for construction of that facility. There's one that's currently under development in Henderson County, and it's currently under development, so they don't have estimates on total employment, but it's about twice the size, and it would have about 150% of that. There is obviously the company I'm working with is committed to hiring locally, to using local contractors to the furthest extent possible. But there would be a tremendous amount of construction hires, long-term, permanent employees. There will be people on the ground. All of these are obviously regulated pretty heavily all these facilities are regulated heavily by both state and local government. So there's people to maintain compliance, but it would be probably a handful of permanent jobs.
You think it would be less than 10, less than 5? Can you ballpark that at all?
Between 5 and 10, I would estimate. Less than 10.
Okay.
And again, that would depend somewhat, Judge, on the size of the facility. I don't want to speak for all projects, but obviously a much larger scale project would have more probably permanent employees.
Mr. Daniel, quick question.
Yes, sir.
As opposed, I guess my question is why the decision to go through a text amendment versus, maybe a map amendment, or basically coming up with its whole other classification, just for solar farms? Can you kind of tell me why it went the text amendment way?
Yes, sir. Part of it was we listened to what the local leaders were saying and the planning office was saying, where there is not currently in the zoning ordinance any mention of solar at all. Really, a map amendment probably doesn't make sense, because even if you zone land heavy industrial, there's no mention of solar in heavy industrial. So it wouldn't be a permitted use under any current zone classification we have in Clark County. The other idea was that because the way we are geographically in Clark County, the transmission lines really lie primarily in agricultural areas. And we anticipated the desire to keep those areas agricultural long-term. And so if it is a use within an agricultural area, there will be a requirement that if it ever ends up not being used as a solar facility, it would have to be used for an agricultural purpose. The proposed ordinance addresses those concerns by requiring a decommissioning bond to be posted to ensure that would happen. So really it was, what does our current zoning ordinance allow? It wasn't mentioned anywhere. So it was going to take some type of use that would allow for solar, period. And the idea, rather than kind of piecemealing them one by one, the idea was, and this is learned from prior experiences, when you have a kind of a new type of economic development, sometimes it makes sense to make a special class for it, where it's going to impact the community as a large, full scale, rather than individual properties one by one. There was conversation about making it a conditional use within a specific zone, and there was also conversations about doing individual map amendments on a case-by-case basis. Those are all alternative ways to do it. Again, we were kind of working with the folks in the planning office and listening to some of their advice about that. But there are multiple ways to do it. There's not one perfect way.
One question I would have is that, and you hit on it, they're at the end of conditional use or non-conforming use, or what was it? And maybe you don't know, maybe it is the planning and zoning that decided it, but why did you not go that route rather than the text amendment route? And the other question I have is, how long have you or this company been at this, pursuing this text amendment or whichever the case may be? When did this idea come to the planning and zoning at first?
Sure, thank you, Magistrate. So the first question, why did we not do conditional use? And the primary reason for that was the conditional uses are generally reviewed differently than proposed text amendments, and the process goes to the Board of Adjustments versus through planning and zoning. Both those committees do good work, obviously, but because and this is partially from the directive from the planning office too, but this is obviously this would be a large change for our community. And it was thought that each of these should pass through the planning and zoning. Each proposed solar facility should pass through planning and zoning versus only being considered by the Board of Adjustments. To your second question, the specific developer we've been working with has been working with planning and zoning since September. That's when they first met. I did attach in my letter kind of a timeline of what's taken place. Our office has been involved really since last fall was when we were engaged. Now conversations amongst everyone started really in March. We've had two kind of, like I said, Zoom conference calls. One as a preliminary conversation, and the second one we drafted an ordinance, and then the third one, I guess we got feedback from folks as to where that should be. And we drafted that ordinance at the request of the planning office. We were working all together really to come up with this, recognizing that there'll be a lot of time for community input into that in addition to the planning commission. So,
Judge, I had a couple of questions.
Go ahead.
Thanks, Mr. Rom, for coming here tonight. And I wanted to ask you a few questions just to clear up some misconceptions or some ideas that people have. As you probably know, John, there's been a lot of discussion the last couple weeks about this in the community, social media. I've gotten a couple of texts and calls about it. So first of all, I want to ask, I want to make clear, in my understanding from what you're saying, that, and from what I've studied on this, that it's not a solar farm, so to speak, is not going to be sited on a 5 or 10 or 15 acre tract somewhere. That in most cases, to get to that 100 watt minimum, you're going to need a considerable amount of acreage. Is that fair to say?
yes, sir. I don't think it's economically feasible to do a smaller scale project.
And then secondly, obviously getting on the grid is a necessity. So you've got to be on a property where you have transmission line access. So in other words, just because I have 500 acres somewhere, if I'm a considerable distance or too far from a transmission line, I'm out of luck with trying to site a solar farm on my 500 acres, right?
I would say it's less efficient.
Right.
But I would tell you that all of these companies have already had to start the process of getting approval. So, you know, at a certain point, we'll reach capacity. If our community decides to move forward with this, we'll reach capacity. So it's much more economically beneficial to be close to a transmission line.
Sure.
Davis. So the closer you are, the more profitable it is for the developer.
Is it also accurate to say that the topography of the proposed site does play at least some influence as to whether or not it's a good site or not? Is that right?
Yes, sir. I think it's not different than any other kind of, you know, some developments have flatter grades than others, and some developments are closer to roads and things of that nature. So.
Okay. And another concern I've heard and has been shared with me, Mr. Romp, is the environmental impact, if any. So the question has been raised, well, would there be an environmental impact study? Now, I mean, I think solar is generally considered to be clean energy, so I don't know if maybe the concern is about the actual panels, the physical panels, and maybe now I know there's FAA licensing, I think, that's required to ensure there's no dangerous glare of that nature. But what can you share with us as far as any environmental studies, analyses?
So I'm not sure I know exactly what you mean by environmental concerns. I mean, are you talking about water pollution or?
Well, you know, really just frankly, Mr. Romp, it was a concern raised to me by somebody this morning. And I'm not an expert in solar energy, but I'm at a loss as to what, if any, environmental impact there would be as far as a negative impact. You know, it's clean energy, unless somebody's concerned about maybe the decommissioning of the panels once they've reached their life expectancy and have to be disposed of. But it sounds like, and it looks like from when I read through the text amendment proposal, that there are provisions for decommissioning.
There are. In terms of other environmental concerns, there would be like a wetland. I mean, the requirements would be different depending on the site, but there would be wetland impact, you know, reports that would be done, geotechnical surveys that would be done. There would be I just hate to answer the question, would an environmental survey be done? Because that means different things to different folks. So, you know, I don't think I mean, it is a clean energy, obviously. So I hate to answer a question when I'm not sure exactly what the concern would be.
I understand.
You know, I think that, yes, there are requirements built into this proposed ordinance about decommissioning to make sure the materials aren't left on site. That would require any developer to post a bond to ensure proper cleanup and restoration of the property. So if that's the concern, I think that would be taken care of.
Specifically,
sorry, Judge.
Sorry, I was just going to say, since Magistrate Davis didn't have a specific, I've been asked specifically about soil runoff. Is there any concern with that?
And that's what I think you're talking about, water runoff as
well, water runoff degrading the soil and the soil running off as well.
So from my understanding and what's included in the proposed ordinance would be that it would not be like the one that we have currently off on US 60 where there's gravel underneath, where you're going to have a lot of water displacement as a result of it no longer being in its current kind of agricultural state. The proposed ordinance would require that to be taken into consideration. So no, I don't think that would be an issue.
Speaking from as someone who's very familiar with environmental impact studies, they can range from and include everything from endangered species. We call birds and bunnies is one, and bones and stones, I guess, would be ancient burial grounds. I mean, there's surface water runoff, groundwater contamination, and all those things can be included in environmental impact studies. So.
And many of those things are required by the federal government.
I figured they would be, yes. And would have to be done before you're able to begin construction even.
Correct.
What is the amount of the decommissioning bond?
Well, part of that is that it requires kind of constant evaluation. So built into the ordinance right now is to have that done on an updated basis every 5 years and for it to be reevaluated. And the idea is that when these projects start off, obviously the equipment has in and of itself a lot of value, and the longer the equipment's in use, the value of it lessens. So initially, the value of the equipment would cover the bond, and then the longer time goes on, the amount of the bond would increase. So it would be evaluated continuously to ensure that the amount necessary to decommission it would always be sufficient. And built into it, there was conversations back and forth about what percentage that needs to be. Does it need to be 120%? Does it need to be 90%? But that's the idea, would be to have an ordinance that would ensure that decommissioning wasn't going to cost the county anything.
John, I received a letter from some concerned citizens. I believe it was with the Kentucky Resource Council, just in regards to wanting to assist in the drafting of the solar ordinance. Is that something that has been pursued or that you would be willing to look into? Or I don't know anything about it per se. I just was curious.
I'm not aware of this. I'm aware generally of that letter. I obviously have not seen that. I don't think anyone is against having public input. I do think we have a planning office that's well equipped to assist in the development of these types of things. We also have a planning commission that's well equipped in that. All I'm really concerned about is not having an indefinite timeline. There's been some conversations about forming a committee, and I'm a believer that whatever can be done can probably be done in 60 days. And my logic on that, even in the world we live in, I mean, I've had 5 Zoom calls today. I'm sure we've got 100 people on this Zoom conference today. I think there can be a lot of community input in a very short amount of time. So I'm not opposed to working with anyone to draft the best ordinance that protects our community at all. My concern is only that it not take a year and a half, because developers, these types of projects, 100 megawatt facility, I mean, basically it's $1 million a megawatt is the investment. And all of the developers have a substantial amount of money tied up either in options or in leases with, landowners here in the community. And they can't wait forever, as any developer cannot. So I have no problem working with anyone trying to propose an ordinance that makes the most sense for our community. My thought would just be to put a timeline on it. That's all.
Can you give us a view into the window of the profit making behind solar panel farms? I've heard some people talk about sale of tax credits being a major impetus behind that. Is that accurate?
I think it's somewhat accurate. I think there's a lot of incentives in all these clean energies right now, and they change depending on what the legislatures, both state and federal, want to do. So it's similar to an individual who puts solar panels on their roof. I mean, the idea is the energy is sold back into the grid to be used by consumers, and there's a profit associated with that. I think most developers are actually that are interested, that I'm aware of, eventually probably would be selling to a large utility scale type operation. So some of it is speculative in type investments. But I mean, it's eventually just selling power back onto the grid in a more efficient and economical way that's going to eventually be purchased by consumers.
So if someone's main purpose for developing the facility were for tax credits, do you know if any profit made off tax credits would be, for lack of a better phrase, taxable to the local government, or would that be something that would be tax-free and in essence provide no profit for the county?
To be honest, I'm not sure under the current tax scheme the answer to your question.
Okay.
And I think a lot of it, I mean, these can be structured in multiple different ways. So when you're talking about the tax credits, I assume you're talking about the tax credits to the developer. But is that what you mean, Judge? And I don't know the answer to that. I know that a lot of times developers work with local tax ordinances or taxing agencies to make sure that the taxes that are intended to go to the local community stay that way. And that's the way all IRBs really work. So
Okay. That's all the questions I have. How about anybody else?
I have a few, but I'll wait till last.
Judge, if I may, for those folks that are on the radio and can't see the chat screen that's up, Rob Jeffries did also help answer my question, and I'll read it for those folks that can hear but can't see. And he says it is not possible to do it as a conditional use because it isn't listed as one. The proposed text amendment is written so that it would be reviewed as a special use with the Planning Commission. A project such as this would be more appropriate with the Planning Commission, not the Board of Adjustments. The process for special use is very similar to the conditional use process, as it would require a public hearing before it is approved. So I feel like that's probably important for some folks that are listening but can't see that chat.
And just to reiterate process, and I think most of you may know this, but right now we're in the stage of just questioning whether an ordinance is appropriate, not whether any specific project is appropriate. So for an ordinance to become, it has to pass this, it has to be a recommendation from planning and zoning one way or another, your group to pass it twice, the city commission to pass it twice, and then any project would actually have to go back to planning and zoning to also be approved. So there's going to be a lot that would happen before any solar facility was located in Clark County.
And if I understand correctly, Mr. Rump, you're just asking that we keep this ball moving, keep moving forward with it. Is that what we're doing here?
Yes, sir. All I'm asking is that we set a timeline. I think, if there's a resolution passed requiring it to be considered within 60 days, then planning and zoning has to do that. And obviously they could make a recommendation to you not to approve it.
Correct.
I just want to move it forward at this point.
You need an answer.
Yes, sir.
At least, yeah, I get it. And I think it's important everybody understands that's what we're discussing here tonight is can we set a timeline for you to have an answer because your client deserves one, and that's I understand that. Thank you.
Thank you.
Anyone else?
Well, I got a couple, just real quick ones. John, can you tell me where in the comprehensive plan this would address a goal or objective and how it would accomplish that particular goal or objective? Because it seems to me like before we can go amending a regulation, we need to have an objective in mind that's listed in our comprehensive plan.
I think there's lots of mentions of economic development within the comprehensive plan. So I think just checking that box right off the bat, obviously solar energy in and of itself is not mentioned in the comprehensive plan, or solar facilities, excuse me. So the idea is to address an issue that has come up since the adoption of the comprehensive plan that really wasn't considered at the time it was adopted, really. And economic development, I think, is a core principle throughout the comprehensive plan. And that's one area, obviously. I actually think that protecting current agricultural classifications is another. That's a cornerstone of our comprehensive plan. This proposed ordinance would ensure, an argument could be made, a solar developer right now could come in here and build a solar facility because we don't have a prohibition against it. So the idea is to do something. I can tell you our client would never do that, but the idea is to do something that's going to provide an ordinance. And really at this point, just tell developers whether this is something that our community wants right now or not. But it would provide an ordinance that would be protective of agricultural land in the long run.
What current regulations are at the state level that address this issue?
Well, there's regulations of all the regulations that apply to electricity in a lot of ways apply to these facilities, but there's also a lot of federal regulation as well. Are you asking about the specific legislation?
Well, I don't want to be in conflict with an alternative regulation. And if they have jurisdiction, what are we doing this for? Or do we have jurisdiction? There's a myriad of questions that could be answered and asked based on what's out there currently. And,
yes.
And obviously this regulation that you've proposed, I looked at several others. So it's probably a model regulation from some other state, city, or municipality. You didn't come up with it all on your own. And I don't know where this came from because it looks eerily familiar to several others that I have seen. So there has to be other regulations involved from other municipalities, other states, and other levels of government. I just wondered what those are and if you were familiar with them.
Well, part of it is in terms of being in line with all laws. Part of this ordinance, section 8.104 part 6 says that it's got to comply with all laws. state, local, federal, otherwise. So yes, it would have to be in concurrence with state and federal law. And I think that those would preempt whatever we do anyway. In terms of the process for developing this, yes, we looked at, the developer that we were in conversations with has general counsel that does this throughout the entire United States. We've relied on their expertise. We've shared ordinances. We've talked about ordinances with Rob Jeffries and the other folks that I mentioned. Kind of picked a lot of things to make a fairly robust one. Some states have adopted model ordinances. Kentucky has not. And so we've kind of picked from what has been done and what has worked from other communities. I will tell you that Henderson, Kentucky has a very different ordinance. It's 1 page long and it doesn't have all this detail. So the intent was to try to anticipate potential issues, a lot of which the court has identified tonight, and to address those on a piece by piece basis, and then address other issues that we haven't talked about, distance from residential areas, distance in terms of screening and buffering and those types of things, to make sure that concerns that people might have could be addressed early on.
One final thought. I don't know if it's a question or not, but it could turn into a question. I noticed there's a sizable fee involved, and I was just curious as to if the Planning Commission would have to seek outside help in reviewing these plans because the fee is so significant. They would have funds to do that. And then I guess, part of that review fee is for different timing and different things. It would appear to me, and again, I don't know, maybe the Planning Commission is qualified to review this. What's involved in the review of this particular document?
Yes, sir. The idea was to make sure that there wouldn't be, to propose an ordinance that would allow the planning office to have sufficient funds to hire outside folks to help it evaluate these things. So specifically, you're going to have traffic studies done. You're going to have a decommissioning security and evaluation done on a regular basis, the road security that would be required. So the idea was to make sure that the planning office, and this was done again with Rob Jeffries' input, would have sufficient funding to do all of the evaluations that would be required for this type of development.
And just a final comment, and I'll be quiet. Since any proposed text amendment can originate with the fiscal court, the Planning Commission, or any legislative body, I really don't know why we have a resolution here tonight, since it's obviously originated with the Planning Commission. So it would appear to me as though that the Planning Commission has taken the lead on this. They should remain the lead body, and I really don't see a need for us to consider a resolution tonight. And I'll be quiet. Thank you all.
And just to address that comment, the Planning Commission, its last meeting, after it talked about this for the second time, specifically requested direction from the legislative bodies. Following that meeting, I communicated with the director, Rob Jeffries, and asked him, was the vocal support from a couple of the magistrates that was voiced, was that sufficient, or did they need official action? And he thought it would be better for the commission to have official action from the legislative body, who's obviously responsible to its voters, to vote whether or not we wanted to even move forward at this stage. So the commission has actually asked for your input.
And that's kind of getting the cart before the horse, but that's okay. Thank you.
I understand.
Well, I think it is. I think it is appropriate for us to make a statement as to this. This is a fairly novel issue for Clark County, i.e. a solar farm, other than the one we have out at East Kentucky Power, their property on US 60. It's something that's pretty new. It's got a lot of people concerned. Some are for it. I think some have already set against it. And as I said in our last meeting, I'm not going to make any statement up or down on it, but I do think that we have an issue with process. And when I watched that last planning and zoning meeting, there was discussion about putting yet another committee together to review this. And honestly, that's the job of the planning staff and the Planning and Zoning Commission, and then the legislative body to take it up as to whether or not we want to accept that recommendation or not. So I am in favor of making that statement, and we make that usually that kind of statement via a resolution. So I know normally we would not be, bouncing an issue back and forth like that. But this is sort of a novel matter that has come up. It is a text amendment. It is a big deal. I mean, and let me just say, for any of those watching, having read the resolution, I mean, really all we're asking for or directing is that planning and zoning consider the text amendment. We're not asking him to rule on it one way or the other or come to one decision over another. We are asking them to take up the matter and go through the process. So I just want to make that clear that whatever occurs tonight, this is by no means a final ruling or final decision on whether or not there are going to be solar farms in Clark County. This is just whether or not the process is going to go forward as it should, which is planning and zoning. And I agree with Mr. Jeffries. I think that is the proper route. And of course, as John, as you pointed out, there'll be a public hearing. There'll be vetting by planning and zoning. I mean, we have an excellent group of members on that board who really dig into these issues, and I expect, and they may tweak or considerably revise what Mr. Romp has submitted. I don't know what will become of that, but I do think, given the unique nature of this, probably is appropriate that we adopt a resolution. And I can understand why they would appreciate having that direction.
And we do have two other speakers under this item on the agenda. If there are no further questions for Mr. Romp, I'll allow them to speak. Okay, is Dave Fowler on the call?
And Judge, he is viewing, unless there's specific questions for him, he's not here.
Okay, so we don't need to speak with him. What about Douglas Schulte of GeneX Solar?
Yes, sir, I'm here.
Did you have a presentation you wanted to make?
I do have, and I'm here with Kara Price, who is the Vice President of Project Development and Permitting for GeneX. We're going to let her start off the presentation, if that's all right, and the two of us will jointly make the presentation.
Okay, go ahead.
It's okay if I share my screen with y'all?
You're down as a presenter, so I guess you can share the screen.
Okay, let me do this. Okay, here we go. Just do a little slideshow. First, thank you very much for allowing us to be on the agenda tonight. And I just want to reiterate what Mr. Rump said, that we were kind of coming in just to kind of introduce ourselves as a solar developer in Clark County. We have a project in early stages of development, and then found out what Mr. Romp and his client were already working on, which was a solar ordinance. And we have certainly looked at the ordinance and think it is a very good ordinance that protects both the county as well as allows for solar development to move forward, which we do believe is a great economic development tool. We actually worked with Harrison County, Kentucky, to draft a very similar ordinance last year so that they could allow for solar development. They haven't yet had a project go through the permit process, but they do have their ordinance in place. So they're excited about the potential there. But I'll kind of quickly go through a little bit about GeneX and our project, and maybe it will answer some of the questions about solar development that you had, and we're happy to answer any additional questions. Just a little bit about GeneX Solar, who we are. Our corporate office is based out of Charlotte, North Carolina. Our first projects were in Eastern North Carolina, started in 2012. As you mentioned, we are a utility scale solar developer. So this usually means very large projects that instead of connecting into the distribution system, they connect directly into large transmission corridors, which is what you talked about in regards to, you can't just use any land for solar development. You've got to have the transmission infrastructure there and the ability to interconnect, as well as a transmission system that has the capacity to take your power, which is key. We have been, by this time, was there a question?
Yes, I'm sorry, Judge.
Yeah.
There was a message that just popped up here. I think Robert Blanton got kicked out. Magistrate Blanton did. We need to hold off until he gets back.
I'm
Oh,
back.
Dean.
I'll log back in.
All right, sorry.
That's okay. Just anyway, a little more detail about how GeneX Solar out of North Carolina. We are now developing in 5 states. Kentucky is our newest state that we're developing in. We are also the founders of a nonprofit called the Center for Energy Education. This is a facility. It's actually located in Roanoke Rapids, North Carolina, next to a 20 megawatt solar project we developed that's now owned by Duke Energy. And from this facility, there are all sorts of educational programs, STEM summer camps for students, train the trainer programs, which are teacher training programs that we give them renewable energy kits to take back to their classrooms. We also do workforce development programs. We have construction courses where we actually bring someone in, teach them the skills to put a solar project together, and they leave with their OSHA 10 and can immediately go onto any site and get hired. So we're very excited about what those programs can do. Unfortunately, this year, our summer camp programs are all virtual, but we already have a large number of students across Kentucky who have signed up for the summer camps, and we're excited about that. So I'll kind of quickly go through here and talk a little bit about utility scale solar. Maybe this might answer some of your questions. Obviously, you know enough. I don't come into solar from the engineering side of things, but it's a very simplistic process that you've got. You've got the solar panels that absorb the light. That's why there's not a lot of glare from a solar project, because all of the panels are coated with an anti-reflective technology, because it's our job to get as much light in as possible. You then take that DC power and it goes to an inverter on the site, converts it to AC, that power that we use every day in our homes and offices. There's a transformer and substation on this project site that takes that power and puts it up to the voltage of the utility grid. And then it immediately goes into the utility grid and off to where it can be consumed. I know there were some questions about environmental impacts, and solar has been around for more than 50 years. NASA was one of the first people to use it. There's no emissions or contamination. There's nothing in these panels contained. It's just glass, silicone, and wiring when you see them, much like would you be used in your cars. There's no noise outside of the fence line. The inverters, the transformers, they all have a hum, just like your air conditioning units would have on your house or business, but they're all designed well inside the fence line, so there's no noise that extends beyond that. As I mentioned, there's no glare. The health and safety of these, more than 90% of the materials that are used on a solar project can be recycled. They're actually certified that they can either be recycled, or actually they're allowed in landfills, which kind of shows that there's nothing hazardous in the solar panels. We often talk about solar as one of the only developments where you can actually return the land to its original use after the life of a solar project, which you can't say for many other types of developments. And why is this happening now? You know, I think Kentucky is just going to be a place where there's going to be a lot of solar to come. You have, for different reasons, you have coal, you know, that is, there are plants that are retiring now. Something's got to replace that power. You have the demand from companies like Facebook, Google, Amazon's large corporate consumers of power want to say they're sourcing their power from renewable energy, which drives the demand for these projects. We already talked a little bit about size, and as Mr. Romp alluded to, it's the economies of scale. These projects are competing in a marketplace now against coal, gas, and other types of power sources, and it takes a certain size in order to do that. Kentucky has what North Carolina and Virginia and other states in the area have for solar, and that's, you've got good sunlight, you've got to have good topography, and you're near an area with high energy demands. This power feeds into what we call the PJM marketplace, which is the second largest energy marketplace in the world. Comes up from northeastern North Carolina all the way up into the Northeast and over to the Midwest. And you obviously have available land that already has existing transmission infrastructure, which is key. And then you've got to have the willing landowners who want to diversify their income and protect their real estate assets. This is their future. This is their retirement. And a lot of times people are using this to keep that land in their family without having to sell it off for more intrusive commercial development. This is just a little, conversation about how we acquire our land. Most of it is long-term leases. These are leases with the landowners for up to 40 years. So that's that guaranteed income they have over the life of the project. We also have a lot of studies done about what happens to the people that live next door. That's important for us. People don't like change. And we have to ensure that we're taking care of those neighboring landowners with buffering, with screening, with setbacks, as this ordinance would take care of. There's also been a lot of studies done now with solar, which has been in North Carolina for over 10 years. They've actually looked at land sales and home sales before and after a solar project went in and determined that solar doesn't have an impact. It doesn't have all those things that create a problem with home value. Once it's constructed, it's one of the quietest neighbors you could ever have. There's no lights at night. There's nothing else that's going to be there. You're not going to have traffic. You're not going to have noise and other smells. The permitting oversight, I think this was kind of key to some of the earlier conversation. There is a state level process we have to go through. Not only do you have federal oversight with your Army Corps of Engineers looking at the wetlands on the land we're using, the FAA administration has to look at the glare for any local aviation. But in Kentucky, you have a state siting board that is with Utilities Commission. And it's one of the reasons timing is so key. That state process is very intense, and it can take 8 to 12 months in and of itself to go through the process. And along with that process, we have to do a lot of impact studies on that land, from wildlife. Are there any endangered species? There has to be a full cultural impact analysis from archaeological perspective. Those studies are long and intensive and very expensive. And as part of that, they want to see that we've already met the local standards before we even move to that process. So that is one reason you kind of have to look at the county and say, okay, we want to engage with the county, figure out what they need from their regulatory standpoint before we can even move to the state process to get this project to be reviewed. Obviously, the state driveway permits, stormwater and erosion control is key. And then coming back to the county, you might have any zoning, as we're talking about here in regards to an ordinance, and then the building and electrical permits that will come closer to construction time. And while all this is going on, these projects are also going through an extensive process with the PJM, the transmission operator, as well as the local utility, to determine that the capacity is there and what the costs are going to be for us to interconnect to the system, and if there's any issues or delays that are going to happen during that time. And it's one reason you don't hear about us till further in the process. We filed the interconnection, but it takes a while to get through all those studies, and we don't know for like 6 months after we file if it's even feasible to interconnect in that transmission corridor. So there's a lot of things we have to figure out ahead of time. And this was also discussed, a decommissioning plan. Part of our landowner agreement with any landowner we have in our project is a decommissioning agreement that we will take care of removing the project from the land at the end of its useful life. So not only do we enter into that agreement with the landowner, certainly enter into the same agreement with the county, and we're willing to post any surety that the county agrees to remove this project at the end of its life. We're really not here. I think at this point it was more about the ordinance and just letting you know solar is coming to the county and we want to be part of the community. We do have a project in the early stages of development that is a fairly large project here in Clark County, but we will certainly be coming back to you later to go into more detail about that project and its location and the specifics of it. But I think, as someone else mentioned, we're putting the cart before the horse if we go into too much detail here on that, till we can see how the county wants us to work with them as solar developers. Some of the benefits that have already been mentioned, I believe, as part of this and why we think an ordinance is a great thing for Clark County. In addition to the tax benefits that have been mentioned, property tax, there's a lot of other economic development benefits. There's the workforce development. Projects of this size and scope, the construction process can last anywhere from 18 to 24 months. And with a minimum of 150 to 200 hires, I think you heard already that there was a project smaller that had up to 400 hires at that time. We obviously have permanent positions that are supported. I mentioned the workforce and education development programs. There's the increased business during this time. These people that are working on these projects have to have somewhere to go buy their batteries. They have to have somewhere to rent local equipment. We need local fencing contractors and people like that to support these as well. And then there's the property tax revenue that has been mentioned. Additional community benefits. Obviously, we've mentioned the Center for Energy Education, which we support, but I'm sure other developers have, unique programs that they bring to the table. In addition, I think you'll find a lot of solar developers are willing to work with the community and find out what we can do and provide other benefits package to the community, whether it's through payment in lieu of taxes negotiations, special economic benefits, or community benefit programs that we put together. But there's a lot of unique things that can go along with solar development that make a huge impact on the communities. And Doug, I'm so sorry. I just kept going and talking. Women, we won't shut up.
That's
So,
all right. You see my lips move.
so if you would like to add anything, but Doug Schulte is our Director of Operations in Kentucky, the man on the ground there. And we also have Aaron Caldwell, who's in the audience. He's our Manager of Land Acquisition for the region. And then we have our Executive Director for the Center for Energy Education who will be involved. But any of us are available at any time to answer questions. And thank you very much.
Did I understand correctly that your plan in Clark County would be to lease any potential land from a farm owner and not to purchase?
We would actually do either one. If, typically we find that one of the great advantages to the farmers and landowners in this situation is that, and Kara, go ahead and unshare your screen. Is that, most of these are family-owned farms, and their driving force is to try and keep the family farm together and maintain it over a longer period of time. Being able to lease their property to a venture such as this gives them the opportunity to do that. And even if their children aren't necessarily interested in farming the property, they can continue to maintain the family farm and collect revenue off of that property moving forward. We are willing to purchase property if people have that as a preference, but we usually find that maybe 10% of the people are interested in selling their property and the other 90 are wanting to simply lease it. That they kind of want to keep things pretty much as they are.
Does leasing the property typically change its intended use in a manner that would change the property tax valuation to no longer require the exemption?
Yes, that is correct. We're pretty much used to that in most of the states that we develop within, that it has an agricultural value. And once we put the solar equipment on it, is reevaluated as a commercial value. And the developer will take care of those increases and pay the taxes on the project.
When you do purchase land in Kentucky, typically what is the price per acre? I'm not saying you have to lock in a number, just a guess.
Doug, I'll let you answer that because I don't deal on the land side. I think Doug got frozen. Is he frozen? I think we
I don't
lost.
see Doug.
Yeah, I'm sorry. I think we lost Doug. I don't know. Aaron, could you answer that question?
I can comment generally. Typically, there's a rent rate for the property when we lease, and oftentimes we come in when we purchase a property at approximately 10 times that rent rate. So without giving too much industry information, that's what it typically looks like.
So let me see if I can find another way around this. Do you own a solar farm in Kentucky? No?
No.
Okay.
I'm sorry, I missed the question.
No, he wanted to know if we currently owned a solar farm in Kentucky, and no, we do not.
Okay.
All of our project, we are developing in over 5 counties in Kentucky currently, but all of the projects are in early stage and have not moved through.
What are those 5 counties?
Harrison County. We actually have more than 5 then, if we include Harrison County. We have Harrison County, Marion County, Barron County, Clark County, and then is it Madison County, Aaron?
Yes, Madison.
Yep.
Madison?
Yep.
Okay.
And they're all at various different stages in
Go ahead.
their life cycle. So some of the counties are, fully aware of our projects, and others are just learning about them.
Fair enough.
So Judge, one way you might look at that is if you know the value of the property or the average value of property in Clark County, divide that by 10, I think is what I heard Aaron saying would be the typical lease rate.
So say, we have anywhere from an average of lease rates, average of $400 to $600, we'll say, for a rent rate per acre. And then multiply that times 10. And generally that's a starting point for purchasing.
Okay, 6,000 per acre starting point. Gotcha. Any other questions? Okay, would anyone like to make a motion that we consider a resolution approved by the Clark County Fiscal Court referring a proposed text amendment back to the Planning Commission?
Judge, one thing that we may want to consider because of the interest in this, would it be a good idea to have someone, not me, to read the resolution for the public that may be viewing or listening, which I know there is what you would consider significant public interest in this project. So
If you would like me to read it, I will.
I think that may not hurt a thing.
Okay. It's titled, "A Resolution Approved by the Clark County Fiscal Court Referring a Proposed Text Amendment to the Planning Commission Pursuant to KRS 100.211 subsection 3. Whereas, pursuant to KRS 100.211 subsection 3 and Article 14D of the Winchester/Clark County zoning ordinance, any proposal to amend the text of a zoning regulation which must be voted upon by the fiscal court may originate with the fiscal court regardless of the origin of the proposed amendment. And whereas, in all cases, the proposed amendment shall be referred to the Planning Commission before adoption, where the Planning Commission shall hold at least one public hearing after notice, as required by KRS Chapter 424, and make a recommendation as to the text of the amendment and whether the amendment shall be approved or disapproved, and shall state the reasons for its recommendation. And whereas, in the case of a proposed amendment originating with a fiscal court, the Winchester/Clark County Planning Commission shall make its recommendation within 60 days after the date of its receipt of the proposed amendment. And whereas thereafter it shall take an affirmative vote of a majority of the fiscal court or legislative body to adopt the proposed amendment. And whereas multiple developers have determined that it would be economically beneficial to the developers, property owners, and Clark County to develop solar energy facilities in Clark County. And whereas to facilitate and carry out such ventures, the developers have acquired options to purchase real estate and leases at their own cost, procured an engineered design and development plan at their own cost, and incurred other costs, and in coordination with and at the request of the Planning and Zoning Office, one developer has proposed a text amendment for consideration by the Planning Commission. And whereas on May 19th and June 7th, 2020, at the regularly scheduled meetings of the Planning Commission, the proposed solar ordinance was discussed by the Commission. And whereas the Planning Commission requested direction from the legislative bodies as to whether to consider the proposed text amendment. And whereas the Winchester/Clark County zoning ordinance makes no provisions for solar farms as a specified or conditional land use, thereby requiring a text amendment to provide for the proposed ventures. And whereas one developer, the Planning and Zoning Director, Council for Planning and Zoning, the Judge Executive, Industrial Authority, City Manager, City Attorney, and County Attorney have worked together for more than 9 months for the purpose of assembling an appropriate amendment. And whereas the results of such collaboration have been reconciled into the proposed text amendment. And now therefore be it resolved, the Clark County Fiscal Court sends this resolution to the Planning Commission requesting that it consider a zoning regulation text amendment proposal for solar ordinance as contemplated within the statute KRS 100.211. Let it be further resolved that pursuant to the statutory scheme, the proposal be advertised, subjected to public hearing, and findings and recommendations be made back to the Clark Fiscal Court in writing within 60 days.
Judge, I thank you for doing that. And I would say this, these good people have come to our county and spent considerable money in options and development plans to get to the point where we're at. I think that we owe them an answer. To not drag this on. 9 months is too long to begin with. Shouldn't drag on anymore. So I will make a motion to adopt the resolution as read.
I'll second that, Judge.
Motion has been made by Magistrate Elkins, seconded by Magistrate Constantopoulos. Is there any discussion?
Judge, that was Magistrate Thompson.
Oh, I'm sorry. Was that Magistrate Thompson? I'm sorry.
Yes.
Seconded by Magistrate Thompson. Any discussion?
I have some discussion, please.
Go ahead.
I would hope that any public hearing held will be held in such a venue and at such a time that the public is invited and encouraged to attend in person. I know there are several who would like to make public comment and would have input on this. So at any scheduling of any public hearing, I would encourage the Planning Commission to do so amidst the COVID pandemic, to where that the public can attend and can comment, and that the commission, I know, would listen to them. The second item I have is just a personal comment. I've been involved in some of these issues for many years, and this is an unprecedented stance for the fiscal court to pass a resolution of taking such stance prior to the Planning Commission hearing, and I'll be voting no because of that reason.
And I'd like to add to that, Judge, during comment that I would also ask that the fiscal court meeting where this would be considered be held in a venue where public comment can be listened to as well. Should it get back to the fiscal court, and I expect it will. I'm not at all opposed to changing the way things have always been done. So for that reason, I will be voting yes.
Just
Any,
one thing.
go ahead, Daniel.
I was just going to say, you know, one thing is, I mean, I don't think there's not any, just to clarify, and I know you read it, Judge, but, you know, we're not making any formal stance on whether to, for the planning to approve it or not. We're just asking them to give the developers an answer so that way they can decide whether they want to move on or what, because the Planning Commission may deny it and kick it out, or they may approve it. But they need to do the due diligence, research it, have the public hearing, get the public input, and go through the process. And I think that's for any business that wants to potentially locate in our community. We need to go through the process and streamline it and then make a decision. And then at that point, that way they can move on and everybody can go about their way. So I will support that, just to get them an answer, whether it be a yay or a nay.
Further discussion? I guess the only comment I have on this particular resolution is, you know, in some ways it seems to read to me directing the Planning Commission to sort of do what the Planning Commission ought to already be doing. I think that the commission should strive to handle these things in an expedient manner. Give these companies willing to invest in our community a yes or a no, so they can either come in or leave. And so if the Planning Commission needs our input as to whether or not we want them to act quickly, I certainly feel they should act quickly. Yes or no, one way or the other. That being said, I guess I'll have a roll call vote.
Magistrate Elkins,
Yes.
Thompson,
He said yes,
Yes.
but I couldn't hear him.
okay. Constantopoulos,
Yes.
Blanton,
Nay.
Graham,
Yes.
Davis,
Yes.
Judge,
Yes.
61 carries.
Okay. Now moving on to item number 7, Clark County Sheriff's Office 2019 Tax Settlement Report presented. You all should have a copy of that. Are there any questions for the sheriff? Okay, moving on to the next item. Item number 8, review of the Clark County Administrative Code pursuant to KRS 68.005 subsection 2. I'd just like to open the floor for anyone who might have some comments or potential changes they would like us to consider in the administrative code. I can tell you that upon passing our budget, if it passes later on in this meeting, I do foresee some changes in the code that we will need to be making in the near future. So if there's any input that you all would like to give me now, I'll be more than happy to take notes on it. Or if you would just like to contact me in the upcoming weeks, I do foresee us amending the code in the fairly soon.
Judge, when you say fairly soon, do you mean next 2 months or?
Yes.
Okay, thank you.
Judge, the only comment that I had is I think I mentioned it in the magistrate or mentioned it in the previous meeting. And I think, correct me if I'm wrong, I think Magistrate Thompson agreed with me. Just something in regards to the financial procedures, in regards to making sure, with the department heads and constitutional officers before any bills are submitted or purchased, that there's adequate money in those funds, and then, transfers be brought to us before those funds have been actually spent. So then that way it doesn't put us in a bad situation on whether or not to approve these transfers and so forth. The court can make the decision at that time. So
you would like inclusion in the administrative code, a section regarding purchasing and department heads and constitutional officers being required to check available cash balance before they make a purchase. Is that, am I understanding that correct? Okay.
Judge, I would add just an addendum to that, and I think it's consistent with what Magistrate Constantopoulos just offered. And I think this has been an issue definitely this fiscal year, but I think upon the receipt of any bill or invoice, a copy of that or the original, one or the other, needs to be forwarded to the finance officer, in my opinion, within 3 business days after it was received. So we don't have a department head, a constitutional officer, whatever the case, sitting on a bill, whether it's intentional or not, for, potentially days or weeks at a time. So I think that we need to tighten up that process of turning copies of those invoices over as quickly as possible. And I would suggest 3 business days, but if you preference judges 4 days or 5 days or whatever, but there needs to be some tightening up of that process. So that's my thought to that point.
Okay. Anyone else? Okay. I'll finish writing this down. All right. Moving on. Item number 9, consider approval of the minutes from the June 10th, 2020 fiscal court meeting. Do I have a motion?
Judge, I'll make the motion to approve.
I think Magistrate Davis beat you, so we'll say Magistrate Elkins with a second.
Sure.
Any discussion?
Yes, I have some discussion, please.
Go ahead, Robert.
On the second page, the second full paragraph, and I will read it for those listening. It says, motion made by Magistrate Blanton, second by Magistrate Constantopoulos, to approve order number 2020-56, requesting the City of Winchester to manage the accounting for Parks and Recreation Department, as requested by the Winchester-Clark County Parks and Recreation Board. Well, Judge, I have a copy of that order right here, which, and I guess my question is, I want to know who conjured up this motion and who conspired to conjure up these minutes that we didn't discuss, I didn't make a motion on, we didn't vote on. The only thing, and I can play it for you if you want me to, the city manager, I think, said the only thing we need was something in the minutes. All of the fiscal court members agreed. And when I was looking for this order yesterday, come to your office, which you didn't have a copy, you also agreed that we didn't approve an order. So I want to know who conjured this up to say that we approved an order when it was never discussed. You know, and whoever did this needs to be held accountable, because not only is it unethical, it's probably illegal to record a document that is falsified, because we did not approve any type order on this. All we did was approve a motion to get it in the minutes to satisfy the need. And whoever wrote this wasn't even there. The word accounting was never even used. The word used time and time again was financials. So I need some sort of explanation from someone as to how this all occurred.
Well, I believe that the minutes were recorded by the clerk, Michelle.
I sent
Regarding
Michelle the very word that I wanted her to use. So I don't know who had her change it, but I sent her a text message verbatim as to what my motion was, and it's not fair. I want to know what happened.
Michelle, did someone instruct you to change the minutes?
No, we usually take the heading off of the top of the motion, or top of the order rather. And so
There was no order. There was no order. It was discussion from the city manager.
the order was laid on my desk.
Who laid the order there?
I don't know.
Typically, what occurs, Robert, to answer your question.
I know what occurs, Judge. I want to know who took the liberty to change my motion to say that we approved an order when we in no fact even discussed an order. Pure and simple. That's what I want to know.
When we have, just let me speak, Master.
Let me say one more thing.
Okay.
If someone feels we need an order, the proper thing to do is to record these minutes the way the motion was made, and prepare an order and bring it back to us at a future meeting for us to consider. Not go in and falsify an order, not go in and falsify the minutes. That's not the way you do it.
Okay, Robert, I spoke with County Attorney Elkins, who did prepare the order, and I think you probably know that, about this. And he said that the fiscal court speaks through orders, not through minutes. And so in order for this to have the effect that the city requested, he had to prepare an order.
Well, we need
now,
to go back.
unfortunately, the county attorney's not here to address that. I would suggest
That's a cover up. That's a cover up, County Judge. That's just a cover up. We've done it for years that way, and there's no sense of trying to get around it. Mr. Elkins obviously wanted to have an order for some other reason. We didn't approve an order. You can't falsify the minutes when we didn't approve an order. That's a false document. You can't falsify those minutes.
If you would like, Robert, I would suggest that perhaps you should make a motion to table the minutes. And if that were to occur, maybe we can take that up.
Because they don't get recorded properly.
But they don't actually become minutes until we approve them. So they're not been approved. They're not minutes yet. We've not approved them. They can be amended and changed.
Somebody prepared an order that we didn't approve, so it makes no difference.
These are not the minutes until we approve them.
Well, I'll tell you what I'll do. I'm going to make a motion that we amend the minutes right now, that we amend this motion on page 2 to just what I sent Michelle Turner after the last meeting. And my motion almost verbatim was, I'll get it for you so I can read it verbatim. So if you go back and look at the tape. Okay, tell me, Michelle. And that's how I want these minutes amended.
Okay. I just looked it up. Move to concur with the city of Winchester and having the city to do the financials for the Winchester Clark County Parks Recreation.
I move to amend the minutes to say that.
Second.
Who is my second? Thompson?
Motion has been made and seconded to amend the minutes. Is there any discussion?
What was it? What was the amendment again?
Just
Can you read that again, Michelle? Can you read that again, Michelle?
Move to concur with the city of Winchester in having the city to do the financials for the Winchester Clark County Parks Recreation.
Thank you, Michelle.
That was the motion.
I can play it for you.
Thank you, Michelle.
Any discussion? Well, might I say that I'm a little bit confused as to the delineation between the minutes and the order and which one is required to be effective, because as I said, the county attorney did advise me when I asked him about this, that if it was not in the form of an order, then it was not an official record of the court that the city could
We
rely.
didn't vote on an order, Judge. We didn't vote on an order. If you want to do that, we can do it at a future meeting.
Well, I will say that typically the county attorney, when we bring up anything like in magistrate comments, when several times we've had someone bring something forth, he prepares an order after the fact.
We didn't discuss an order. We all agreed we didn't need one. Even the county attorney was part of that conversation. He didn't bring it up.
But regardless, we can table the motion until the next meeting, or however you want, but.
Well, I think we need to have a vote on the amendment first, Daniel. So is there any further discussion on the amendment?
I would just offer, Judge, that, if it's the county attorney's position that we need an order, obviously I'd like to hear his opinion on that, the legal basis for it. So
The
it seemed
proper
like
thing to do is,
now, Robert, you got an opportunity to speak. Now you let us speak on this.
I'll tell you the proper way to do it in a minute then. Go ahead.
Okay. Well, you listen for a minute. Now, Judge, as I was saying, I don't, and not to say that we need an order or we can just rely on the minutes. But I think if the county attorney takes the position that we need an order for whatever reason, for whatever legal basis, I don't see any harm, Judge, in rather than trying to amend this, the minutes to suit the opinion of one magistrate, and he may be right. Why not table the entire minutes to the next meeting? We'll take it up at that time when Mr. Elkins is present, and we can have a back and forth with it at that time. That would seem like, to me, the way to handle this. It's not going to disrupt the flow of business in the county if we take it up at the next meeting. So that would be the reasonable approach, in my opinion. So that's all I would say, Judge.
Judge, the proper way to do this is to record the minutes the way the motion was made. If the county attorney feels we need an order, you need to prepare that order. It needs to be put on the future agenda. You can't change the history of what happened. That would be filing a false document. You file what was recorded, the way it was recorded, and what was said. If he thinks we need an order, he should prepare that order. It should be placed on the future agenda so we can consider it. You can't change what happened, regardless of what you do with the minutes.
Assistant County Attorney Perdue, are you on the call?
Yes, I am.
Could you provide us any guidance?
At this point, I'm inclined to defer to Mr. Elkins, County Attorney Elkins, and would like to have him have the opportunity to present his version of what has specifically occurred.
Okay. Is anyone making a motion to table, or should we go ahead and vote on the motion to amend?
I would think that Magistrate Davis is correct. We should postpone this until the next meeting. I'd like at least the opportunity to review what was said in the last meeting before I vote on any amendments or the minutes, and then we can get it at that time. So I'll make that motion.
Okay, motion has been made to table the minutes in their entirety. Is there a second?
Second.
Any discussion?
We got a motion on the floor right now by Blanton and Thompson to amend.
Now, it's my understanding that a motion to table is superior. And I could be wrong about that, but that's my interpretation of the rules.
That is correct. And I'm motioning to table all action on the minutes and the amendment of the minutes until either table or postpone. I think the proper verbiage is postpone.
Postpone. Who is my second?
Magistrate Davis, I believe.
That's correct.
Thank you.
Any discussion? Seeing none, I guess a roll call vote.
Magistrate Thompson,
No.
Constantopoulos,
Yes.
Blanton,
You can vote to postpone, but you can't change what happened. So I'm going to vote no.
Graham,
Yes.
Davis,
Yes.
Elkins,
we're only postponing for clarification, I vote yes.
Judge,
I vote yes, it's a legal question.
5-2, motion carries. And is that to postpone to next court meeting?
Yes, ma'am.
Thank you.
Okay. Item number 10, consider approval of the transfers.
Judge,
Have a motion.
what's the first transfer that we're going to be looking at? Because we've got multiple.
Okay. I ought to be getting used to this. The first transfer starts with 01-9200-9990 contingent appropriations in the amount of $27,652. Does everyone have that one in front of them?
Yes.
Okay, do I have a motion regarding
Motion
that?
to approve.
Motion to approve has been made. Is there a second?
I'll second.
Go ahead.
Any discussion? Seeing none, all those in favor respond by saying aye.
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 Those opposed? That motion will carry. Okay, we have a second transfer order starting with the heading 03-9200-9990 contingent appropriations in the amount of $89,733.88. Do I have a motion?
Judge, I have a motion with that with a friendly amendment.
Go ahead.
On that transfer, I spoke with the treasurer today when I was reviewing this transfer. The second from, it has 0192009990 from a contingent appropriations into building repair for the jail. I don't think that's the appropriate line item to take that from, since it's from the general fund to the jail fund. So I conferred with the treasurer in regards to there's a sufficient amount of money to take it from 03-5101-130, which is deputies and matrons. So the only thing that will be changing on that is just the account number and the description.
Okay, I will accept as a friendly amendment, changing the source of the transfer from contingent appropriations to deputies and matrons with their corresponding numerical values.
Judge, just let me clarify that account number, please. It's 03-5101-1030.
1030. Did you get that, Michelle?
Did.
Okay. So friendly amendment has been accepted. Motion has been made by Magistrate Constantopoulos. Is there a second?
Second.
Second was made by Magistrate Davis. Any discussion?
Judge, I have a couple questions.
Go ahead.
Does that get the jail fund in the positive?
I think the attempt that we are making tonight through these transfers taken collectively is to get the jail fund in the positive. But this one all by itself, I think it's collectively.
The last order, transfer order that we have doesn't have anything about the jail in it. So does this transfer get the jail fund in the positive along with the first one?
I think we still need to make a cash transfer. We still need to make a cash transfer.
Yeah,
Okay.
this only gets the line items within the jail fund positive to where we can pay these bills. It's only shifting money inside the jail fund from one line item to the other. That's what this
Basically, this corrects the issues in the accounting software. We need to make a cash transfer after this to correct the cash balance, if that's what you're
That's the
asking.
clarification I wanted. Thank you.
Okay. Any further discussion?
And this
Okay.
judge would bring, this zeroes out the contingent appropriation within the jail fund that we moved money into in January or February. I don't remember the actual month it was, but we shifted more than $100,000 into that fund or into that line item, and now we're zeroing it out to nothing.
That is my understanding. If you'd like, I can get the treasurer to answer definitively.
And one other thing that I would ask, and I know the answer, but I want to ask it anyway. There may still be costs or invoices or expenses for the month of June this fiscal year that we have not yet seen. Although I understand that everyone that the jailer has received have been moved over or brought to the courthouse, to your office, but there still may be others that we haven't yet received for the month of June, including maybe a payroll, or does this include all payrolls for June?
My finance officer tells me payroll is included.
All payroll for June, even
the entire month of June. She says that was taken care of prior to this yesterday.
Okay, so where jail employees are working today, tomorrow, Saturday, Sunday, that is estimated and included in this transfer.
Well, they won't be paid until next fiscal year, if that's what you're getting at.
Correct, but the expenses are incurred in this fiscal year.
Yeah, I don't think that would have been accounted for. No. Yeah, typically payroll is everything is done when they are paid, not when they worked.
Okay, thank you. I was not sure about that. Thank you.
Okay. Any further discussion? Okay, seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. We have another transfer order. This one starts with the number 01-5065-3470 rental and polling places in the amount of $153.94. Do I have a motion?
Motion to approve.
Second.
A motion was made by Magistrate Constantopoulos. The second was who exactly?
There were two of us, Judge. I did. I think maybe Magistrate Davis did as well, so pick one.
No, it wasn't me. I don't think I seconded that one.
I did.
Magistrate Graham, sure, he needs to be on the minutes. We'll give that one to him. So a motion has been made and seconded. Is there any discussion of this transfer order? Seeing none, all those in favor respond by saying aye.
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 Aye. Any opposed? That motion carries.
Judge,
Yes, Daniel?
in regards to the transfers, we have the transfer order that I had postponed until this meeting.
Yes.
And so we need to take that up because that is going to make certain accounts positive for the for bills to be paid. Does everybody have a copy of that from last time or no?
Could you read that for us, Daniel?
Okay, the original transfer was from 0392000990 contingent appropriations for 5,167, and that was being transferred to account 0351013340 building repairs for $554, 0351014110 cleaning supplies for $2,463, and 0351014130 jail management system for $90, and 0351017250 other equipment for $2,060. And Judge, I would like to offer that up as a motion with the amendment of changing again that first account, the from account from the 0392009990 because that account was exhausted with the other transfers that we did. And then remove that or change it to the 0351011030, which is deputies and matrons. The amounts stay the same, but it just comes from those accounts, and there is money available in that.
There is sufficient money in deputies and matrons for this transfer, correct?
That is correct, yes.
Okay. I think we can accept that as a friendly amendment and a motion by Magistrate Constantopoulos. Is there a second?
Second.
Magistrate Graham seconds. Is there discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Any opposed? That motion carries as well.
Judge,
sir,
one last discussion that falls under transfers. Magistrate Thompson brought this up early, but we need to discuss doing some type of transfer to make the account go from the negative to cover all these bills, because this should be our last meeting unless there's any type of issues or anything. I mean, we're going to have to take do our best estimate. I know we tried to get some definitive numbers to make a transfer from the general fund, basically supplement taxpayers' money into the jail to make sure it's positive.
Is that item number 21 on the agenda?
No, that is for 2021, where they're starting off in the new accounts. That'll be effective July 1st.
basically those other two that are later on the agenda, Joe, are to make sure that those actual bank accounts, if you recall our earlier item we discussed maybe either 2 or 4 weeks ago, I don't recall, to set up separate accounts for each fund so that the numbers reflected were cash balances and not computer system balances, which gets awful confusing to people. That's to fund those 2 bank accounts, one of them being the jail, one of them being the road. So Daniel, I understand that you've referenced Magistrate Thompson in the discussion earlier. You would like to make a motion from the general fund to make a transfer to the jail fund to cover the negative balance. Is that correct?
Yeah, I mean, that's what we're going to have to do. I mean, that's the only way we can get money into that account.
Is there a number that you're proposing, or do you just want to discuss it?
I'll discuss it. I mean, I've got some rough numbers, put together. I know we tried to get exact amounts, but I mean, it's tough to do. Does anybody have any specific numbers?
Magistrate Thompson, do you have a number?
I do not. That's where I was going earlier. I was curious what the jail fund balance was going to be after those transfers, or I guess after the bills that we're getting ready to pay more specifically.
My understanding, it would be negative around $300,000.
Yeah, that's the numbers I've got after I took the bills, and what, currently that account's negative $168,549. We've got $2,623.97. It's due to be paid on one set of bills list. And then we've got a bunch of outstanding invoices for $134,007.48. So my recommendation is that we've got to bring that account to the positive. And the only way that I can see doing that, and I'm take suggestions, but is that we take out of the transfer out amount of 014909000 in the amount of $305,196 into the 034910000. So originally we had budgeted 600 and some thousand. So with this transfer, it's going to be a total transfer from the general fund into the jail of $1,063,958, or excuse me, $1,063,958 would be our total transfer in for fiscal year 20. So it's roughly about 421,000 over what we budgeted.
Okay, Magistrate Constantopoulos is making a motion to transfer $305,196 from account 0149090000 to account 0349100000 to cure the negative balance in the jail fund, correct?
That is correct.
Is there a second?
I'll second.
I think Magistrate Blanton said he would second, but I did not hear it. I just saw his.
I'll second it.
Okay, Magistrate Graham did second. Any discussion?
Yeah, plenty.
Okay, Magistrate Elkins, go ahead.
Judge, I think this gets back to what I warned about in November, December of last year, that we were going to be north of $1 million in transfers if we didn't curb the spending at the jail, and here we are now facing that. But I'll say this, there are a couple of accounts that I don't completely understand that the jail has. One is a commissary account, and I do understand that, but I don't know what the balance is in that exactly. And then there's another one, a Tiger account, that I don't understand anything about, nor do I know what the balance is in that. And I don't know how much money we're talking about there, but it could be as much as 80, 90, $100,000 in those accounts. I would rather better understand those accounts and pull some money from those accounts to reduce the burden on the taxpayers of Clark County if we can, because I mean, this is $1 million+ that we're burdening the taxpayers of Clark County with, that I mean, that's a large amount. I see the jailer is on, and if he could help explain those accounts, I would appreciate it. And whether we can spend money out. I know the commissary account has some very strict guidelines on what you can spend that money for, but I don't understand the Tiger account, what it is, where it's from, and what you can spend that money on.
Okay, I'm going to let Jailer Doyle speak just after I answer what I know about your question. I believe the commissary account just has a couple $1,000s in it. That's what Jailer Doyle has communicated to me. And regarding the Tiger account, he is of the opinion that a transfer from that account would not be legal, as it is the property of inmates. But I may, if I've said anything wrong there, Frank, correct me, but that was my understanding.
No, sure, and I appreciate you saying that, because you've asked the question before you've made the accusations that imply that something was done wrong when it's not. We're required to keep so much money in the commissary account just to do business. The Tiger account is the inmate money. It's illegal. You can't even touch that money. We can't touch that money. It's money that belongs to inmates. Put it in there and pay a family that come in there. So that's illegal. You can't touch it.
Judge, I could barely hear the jailer who's fading in and out, but I think I understood him to say that we can't bother the Tiger account, that it's an inmate account. Is that what he said, or could everybody else hear him? Or
that's the basic gist of what I understood him to say.
So who manages that account then? I mean, how did it get there, and what is it used for? Does it just continue to grow and nobody can spend out of it, or what is that?
That is correct. That is the money that people's families put into these people's account. It goes into the bank account at Kentucky Bank, and that's the reason why that money is there. That's not our money, not your all's money. It belongs to the inmates.
I understand that, jailer, and I thank you for that clarification. Let me make sure I understand it correctly. So if I have a family member that's an inmate, I can go down and deposit money in that account, and that inmate can then spend that money in the commissary. Is that what you're saying, jailer?
from their computer at home in whatever state they're in.
I'm going to repeat what he said, Frank. Maybe you can hear me a little better. The understanding that Manager Elkins has, from what you said, is that the Tiger account simply represents money deposited by family members of inmates and can only be spent by those inmates on purchases, correct?
That is correct.
Okay.
Thank you. Thank you. I did not know that. And I've wondered every time I see Tiger account what that is, and I appreciate the clarification.
Okay. A motion has been made and seconded. Is there further discussion? Anyone? Okay. So, yes.
Last question. What was that amount again that I specified? I just want to make sure I read the right number.
Okay. I've got a transfer from 01490900. What's the title of that account, Daniel?
Transfer out.
Transfer outline of $305,196 into 0349100000 to cure the negative balance in the jail fund. So that is a transfer from the general fund to the jail fund to correct the negative balance in the jail fund.
It's on the receipts. It's on the receipt side of the, it's not an appropriation. It's on the receipt side of the budget or financial report, excuse me.
Any other questions or discussion?
Judge, I would ask that after I know we're going to vote on this, but if this should pass, can we prepare an order that we could keep on record that you might email to me and any other magistrate that would be interested in it?
I would imagine that County Attorney Elkins would have prepared an order, but yes, we can certainly have an order prepared.
Thank you.
If you include that in your motion, Daniel.
I will include that in my motion.
All right. Okay, so we'll now have I guess a voice vote for this motion to cure the negative balance in the jail fund. All those in favor, respond by saying aye.
Aye.
Aye. Any opposed? Okay, that motion carries. Now we have item number 11, consider approval of the bills list. Do I have a motion?
We've got multiple, Judge.
Oh, yeah. The first one starts with Annex account number 0150805718, Bluegrass Kesco, for monthly treatment and service in the amount of $150. Does everyone have that document in front of them?
Motion to approve.
Is there a second?
Second.
Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. We have an additional bills list. Heading Annex 0150805718 to Disponet for air conditioning repairs in the amount of $476. Do I have a motion regarding that document?
Motion to approve.
Is there a second?
I'll second.
Any discussion?
I have a little bit.
Go ahead.
Under election, the $8,900 bill, is that something that we can seek reimbursement from one of these COVID funds, since most of those ballots were mailed as a result of the governor's change in the voting process due to COVID-19?
Well, ultimately, that's a question for the DLG or for FEMA or whoever we were to pursue it from. But if you're asking me, should we try? potentially it seems like something we should try.
Okay. And then down under road, the second one from the bottom, Sizemore's Tree and Bobcat for tree removal, $5,050. Was that the result of storm damage, or was that from some public property, or where exactly were those trees from? I assume it's more than one tree.
Yeah, I believe there was one very large tree, and I think this was all trees that were basically damaged during the storms on county roads. I've got the PO in front of me here. One of them's on Ruckerville Road, removing 4 trees. One of them's on Venable Road. 2 of them are on Venable Road. So we have 4 trees on Ruckerville Road, and looks like 2 trees on Venable Road.
Well, I know someone mentioned to me there's a big tree down in the Stony Brook Park, and I think we're responsible for that too, aren't we?
Ultimately, I think we are, but Parks and Rec does the maintenance, so I guess we'll have to discuss that.
I know we had to have a tree removed about just a few years back that had blown down, so that'll be another one we'll have to do.
Mr. Blendon, there's several trees and it was such a big job that they didn't go through the normal procedures and then we partnered with them.
There may have been, I don't know.
I remember that, yes.
Thank you.
Any further discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. We have another bills list. These are the jail bills that the fiscal court had previously declined to pay because the line items did not have enough money to cover these bills. Starting with 5/12/2020 PO 44709, account 03510133340, Ivy Mechanical Supply for repairs in the amount of $540.
Motion approved.
A motion has been made. Is there a second?
I'll second.
Is there any discussion?
Judge, the transfers that we made earlier will, I guess we'll populate those line items enough to where we can pay these bills. Is that correct?
To the best of our estimation, yes. I mean, is it possible that there could have been a miscalculation? Sure, nobody's perfect, but I think we will have enough to cover these. I will just mention that, there are a few of these that are a little bit older. Of course, the court decided not to pay these bills because there simply wasn't enough money in the line items to pay them. And I've seen some commentary regarding the 30-day limit on paying bills. County Attorney Elkins is not here, but it's my understanding from previous discussions with him that that 30-day limit applies to bills against line items that have a sufficient balance, that they do not, that rule does not necessarily apply against bills that you don't have the money to pay in the line items. That's just as a public note.
That was a point I was going to make as well, that we can't, we're by statute required not to pay bills that have not enough money in the line item to pay the bills in. So that, I think that's a very good point. I'll be supporting paying the bills finally.
Yes.
And Judge, I think that's where it goes back to the admin code where we need to make those changes, because we should never accrue the bills before we have adequate money in those line items.
I took notes of that when you said it, Daniel. And I agree. It's a good practice to have the bills given as quickly as possible so they can be paid, and simply so the budget can be managed accurately. I agree with you.
Well, and the department heads have to check their line items before they make a purchase and make sure that funds are in those line items before they purchase something. So if you want to buy a rake and you've only got $5 and the rake costs 10, you can't buy it until you get a transfer order made that would add $5 more to the line item. I know it's very simplified, but that's basically what Magistrate Constantopoulos is saying.
And I will say, just as a side, I think we've made a lot of progress in the past 2 to 3 weeks, communication wise. And I think we're, looking very positive towards resolving some of the communication issues that we've had with these billing issues. Any further discussion?
Yeah, one more thing. I know I've been very hard times on how this process is done. And you did say something that I feel like needs elaborated on, that we have. I know the jailer has implemented some protocols at the jail, which will prevent some of these issues from happening again. And that's very much appreciated, and the work that he's done towards making sure that we don't incur these issues again, I think is very positive, and I want to commend him for doing that.
Any further discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Okay. Item number 12, consider approval of an order to reappoint Chris Thacker to the Planning and Zoning Commission. Do I have a motion?
So moved.
Second.
Second. Is there any discussion?
Who was the
Seeing-
second? Thank you.
Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Any opposed? That motion carries. Item 13, consider approval of an order to reappoint Ernest Pasley to the East Clark Water District. Do I have a motion?
So moved.
Is there a second?
Second.
Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Item 14, consider approval of an order to reappoint Tim James to the Clark County Public Library Board. Do I have a motion?
So
Motion
moved.
approved. Second.
Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Item number 15, consider approval of an order to partner with the city of Winchester to purchase fireworks for the 4th of July celebration at Likens Park. Do I have a motion?
So moved.
Is there a second?
Second.
Who made that second?
Thompson.
Masher Thompson. Okay, before any discussion, Masher Constantopoulos, you're not going to be the one providing these fireworks this year. Is that correct?
That is correct. It's the company that I work, I'm licensed under. They, last year for the Pioneer Festival, I was unable to do it, and they just step in and fill it in. So I'll be unable to do it this year, so.
Okay, I just wanted to make sure I didn't need to ask you to recuse yourself.
No, and just one other thing, one point, I think, and Magistrate Blanton, you may concur or clarify this, but we've actually already had the money allocated from last year's community fund grant application, did we not?
The committee did that last fall when we allocated funds, so this was already allocated. We're always a year behind, so yeah, this is already allocated.
So we're just
Already
authorizing the treasurer to pay that out then.
Yeah.
Right.
I guess,
Go
I
ahead.
guess the reason is, I guess we need an order to do that.
So just some discussion on this. I felt it was important that we go ahead and have the 4th of July celebration. And we've worked with the city and the mayor and the health department to figure out a way to appropriately do this. Anyone out there in the public, the way it's going to be addressed is it's going to be an in-car celebration. That's at the advice of the health department under the orders of our governor. We will have people being parked out at Likens, and we also expect there to be some overflow parking and the general issues out there. But there will be a 4th of July celebration, and I think the city thinks it's important, and hopefully the county thinks it's important as well. Any further discussion? Seeing none, all those in favor respond by saying aye.
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 Any opposed? That motion carries. Item number 16, consider approval of selling Kentucky Historic Preservation tax credits to Kentucky Bank. Do I have a motion?
Judge,
Yes.
I'll make a motion that we authorize the county attorney to prepare an order that we may authorize the sale of these tax credits to Kentucky Bank, since we need an order to confirm our actions.
Okay, I'll accept that as a friendly amendment. And I'll accept that as a motion from Magistrate Blanton. Is that correct?
That's correct.
Is there a second?
I would second that motion, Judge.
Any discussion?
A comment, I guess, Judge, or discussion.
Go ahead.
At our last meeting, I asked about these tax credits and you told me there was no interest from anyone in these tax credits. What's happened since then?
Well, what we did was we contacted CAECO, as I mentioned in the last meeting. CAECO referred us to the purchasers that they thought would be most interested. After the last meeting, we checked again, and we checked here locally with Kentucky Bank. I think at the urging perhaps of our local, I don't know if he's a president or a vice president, Daryl Terry, that we were able to receive an offer. Now, obviously, the value of the credits is stated at $111,935.16. We're not receiving full value for these credits, if that's something anyone wants to consider. But, you know, I suppose there is a thought that receiving roughly 2/3 value is better than receiving nothing.
That's about the same offer that Mr. Dawson made to me about a year ago. Well, when the tower was just being completed, I had conversations with Mr. Dawson. I didn't have any paperwork because the tower wasn't complete. And then I think about August or September, they were complete and mailed to the county judge's office. So I followed up with that and had Miss Janet Townsend follow up because I didn't have time. And I appreciate her following up on that and being able to complete this sale of tax credits. And if I might take this one step further, my previous comments about the courthouse, I would certainly hope that we can take the funds from the sale of these tax credits and apply them to the much needed exterior maintenance of the courthouse. We've got windows broken out, we've got rotten wood, we've got birds coming in. So I'm going to vote for this. And then under magistrate comments, I'm going to suggest very strongly that we use this money, this unexpected money that we were told last month we wouldn't have, so we could do this deferred maintenance on the courthouse.
I will say that, you know, for the most part, I agree with you, Robert. You are correct. We do have a loose window panel on the jail side of the courthouse. We do have some rotting wood, and we did attempt to take bids once on some restoration. I don't know if we're necessarily required to take bids again. I'll have to check with the county attorney on that, but I do think we've got some issues that we could use this money to cure. But of course, that's at the end of the day, that's up to the full fiscal court. It's not up to me or you individually.
Oh, certainly.
Okay, so motion's been made by Magistrate Blanton. Is there a second?
I did second that, Judge.
Oh, okay. I missed it. I'm sorry. Any further discussion? All those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Item number 17, consideration and acceptance of a composting grant agreement from the Kentucky Division of Waste Management Composting Grant Program for the period of July 1st, 2020 through June 30th, 2021. Do I have a motion?
So moved.
Motion from Magistrate Davis. Is there a second?
A second.
Seconded by Magistrate Elkins. Discussion. I feel like I should give a rough overview of this, if nothing else. As you are all aware, we have a increasing bill in regards to dead animal removal here in Clark County. I think last year we had budgeted somewhere in the vicinity of 50,000. This year it's more so in the vicinity of 70,000. The actual expected cost based on past numbers would probably be in excess of 100,000. So, you know, potentially if we don't have those funds in the budget, we're going to end up having to find some way to allocate resources to different people in the community who use the dead animal removal. Fortunately, we've been able to apply for this grant, and we were awarded the grant. It does require a 25% match, but in Franklin County, under the supervision of, I believe it's Soil Conservation, they have developed a facility for composting, and that is how they do dead animal removal in Franklin County. They don't have any expenses. Now, obviously, other than their own inside expenses, they don't have outside expenses like we do at the current time. The thought would be that if we can use these grant funds, which are well in excess of $100,000, to develop our own composting site, we can expand our ability to continue dead animal removal. As these numbers get north of 12, 13, sometimes even 1,400 animals, we probably can't afford to do it under our current budget and under our current constraints. So this is a creative way that we have found that we think we can use to supplement our current dead animal removal program and make improvements for the future. Frankly, I don't see how we remove all the dead animals without something like this, especially not on a long-term basis. So as a service to especially the farmers in this county, I think this is something we need to seriously consider.
Judge, quick question. Who would be administering the grant and running the program? Is that going to be through the solid waste coordinator? Or is that going to be, how's that?
Well, I've had some preliminary discussions it's solid waste or it's road department, according to where it's been done. In Franklin County, I believe the solid waste coordinator worked on setting it up, and then it's run through the road department, but with fiscal court funds since then. In our situation, road supervisor Curtis has been responsible for the vast majority of the granting process. I had a meeting with he and Gary Epperson just regarding who may be willing to take this on. I'm not saying that either one of them jumped at the opportunity, but I think we need to find a county employee to do this who's already on the payroll. I think we probably need to, address it with some sort of a stipend somewhere in the near future. Whether it be Gary, whether it be Alan, whether it be somebody else. But in the grand scheme of things, spending a few $1,000s in order to save tens of thousands of dollars is probably a good idea.
I agree. I think it's a great idea, and it so far, as best I can tell, been very successful in other counties where it's done. I would caution against commingling salaries and monies when you talk about road department, and I think some of his pay probably is state funds, and this is grant funds, so we need to be very careful with that and how we do it. But certainly,
yeah, I think we need to, for my purposes today, do we want to accept $100,000 plus with a commitment that we'll match it 25% or not? The other issues as to who runs the program, whether there's a stipend and all the other things you just mentioned, I think we deal with those when we have a little bit more information.
Agreed. No, I don't disagree with that, Judge.
Any further discussion?
No further comment.
I agree. I think I've been to several conferences and they've had videos and presentations in regards to this type of process, and it really seems to work well. And I think it could potentially save us a lot of money, and potentially, if everything goes smooth, it could turn into a potential revenue stream for the county as well.
Oh, one thing that I would like to add, just based on prior discussions with the extension, they've been unable to help us directly through extension funds regarding funding dead animal removal because it requires an educational component. My understanding is perhaps in Franklin County and definitely in Clark County, we will be able to include an educational component, perhaps teaching even kids in 4-H about compost and about being good stewards of the environment, so forth and so on. And so I look forward to the opportunity of having the extension partner with us on this as well. Any further discussion? Okay, seeing none, all those in favor respond by saying aye.
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 Any opposed? That motion carries. Item 18, consider approval of an annual standing order to pre-approve certain recurring expenses, KRS 68.275 subsection 3.
Motion to
So
approve.
moved. Second.
You get that, Michelle?
Constantopoulos and Davis.
Yes. Yes.
Motion has been made and seconded. Is there any discussion?
Judge, I had some discussion.
Sure.
I don't have an order. All I've got is a list that says approve outstanding order. Consistent with the county attorney's opinion, I guess we need to have him prepare an order for this as well.
This is an order. It's an annual standing order.
I don't, where does it say order?
The top of it, it says annual standing order. It's an order.
Well, if you say so.
Annual standing order to pre-approve certain recurring expenses. Any further discussion?
Doesn't have our typical whereases and such as it usually does.
Robert, we've done this for 5 years. They've never said that. They've looked just like this form.
We've got a different county attorney, obviously, so we probably need to do things differently.
It's the same as what we've always done.
Okay. Robert, are you making a motion?
I didn't make a motion.
Okay. So a motion has been made and seconded. Is there any further discussion? Seeing none, all those in favor respond by saying aye. Aye.
Aye.
Any opposed? That motion carries. See, item number 19, consider approval of the second reading of the Clark County fiscal year 2021 budget ordinance. Do I have a motion? Okay, I heard Magistrate Elkins and I think Magistrate Davis. Is that right?
I was second, I guess. Was I first or second, Greg? That you? Did you go first?
Good.
I heard Elkins first.
I'll do second.
Okay. Motion made by Magistrate Elkins, seconded by Magistrate Constantopoulos. Any discussion? Seeing none, all those in favor? Oh, go ahead, Travis.
The jailer asked me if he could have the opportunity to address the court before we voted on this, and I told him that would be up to you, but I told him I would bring it up to you.
Okay. I suppose if the jailer wants to address the court, he can.
It would be in regards to the 2021 budget.
Okay. Jailer? Are you there?
Everyone hear me?
Yes, sir.
Okay. Can everyone hear me okay?
I can.
Travis, can you guys hear me? Judge, I'm just trying to see if the rest of the magistrates can hear me.
I see what you have here, Frank.
No, I'm just trying to see if everybody can hear me.
I can hear you.
Yes, we can hear you.
Okay, I've got an answer. I've got a, go ahead. He cannot.
Go ahead.
Judge, I'm just trying to confirm.
Judge, if you remember, it sounds like those old phone calls you used to get where you could hear every fifth word. That's about what I'm hearing.
Okay.
You respond. Can you hear me okay?
Is there anyone who can't hear the jailer? I think we're good, Frank.
I have a prepared statement. I'm going to go through this statement. I'll ask you to refrain from interrupting. We'll answer questions at the end of it.
I can't hear, Judge.
Okay, he said he has a prepared statement.
And we'll answer the questions at the end of it.
Judge, would it maybe be possible to get him on the phone so we can hear him better? It's kind of in and out on my end as well.
Tab, is there anything we can do to help the jailer?
Not really. The only thing he can do is call him by phone and I can add him that way.
Would you like to try that, jailer?
Sir?
Would you like to try calling in?
Yes, sir. Give me just a second. I will.
Okay.
Is the jailer going to call in?
I think so.
Okay, Judge, is everyone able to hear me better now?
Okay.
Everybody can hear, yes?
I believe so.
Yes.
Okay. What I said before was I have a prepared statement here I want to go through, and I just ask you to refrain. We'll hold our questions to the end. I'll be more than glad to help answer anything that we have. Thank you for the opportunity to address the fiscal court regarding the budget for fiscal year ending June 30, 2021. When elected to office in 2015, cost of operation was $1.87 million. Taxpayers contributed 49% thereof. After taking office, staff negotiated contracts with the state and other counties to house their inmates. In 2016, the total cost to operate was $2.68 million. And the taxpayers contributed 31%. We also created a work program to benefit the taxpayers, providing services such as county and state road maintenance, city public works assistance, parks and recreation, county fair assistance, all your festivals, Beer Cheese Pioneer Festival, maintenance to assist at the courthouse and other county properties, cleaning the streets and roads, Clark County Public Schools assistance, jail facility maintenance and repair. The inmate work program has been a success for Clark County and the inmates. Fiscal year ended June 2020, we calculate the jail inmates contributed over 68,000 hours to this community, which equals over $500,000 in free labor, a direct economic benefit. Fiscal year June 2019, the taxpayers' contribution was $896,523. If we deduct the economic value of the inmate work program, the net cost of the taxpayers is about $351,000, or 10% of the total cost to operate the detention center. A furnished chart shows the total cost to operate the jail, contract revenue generated, other income, and the taxpayers' contribution from 2015 to 2019 for your review. Now we come to the fiscal year June 30, 2021 budget. The detention center budget was submitted to Judge Pace. What I received back was a wholesale substitution of our budget. It is the budget that is receiving a second reading tonight. It cuts the jail by 34% in total and specifically cuts staffing by 49%. These cuts make it physically and economically impossible to safely and securely operate the jail. Current year-to-date revenues outside Clark County amount to $1.71 million. Severe budget cuts have alarmed other contracted counties, and they have informed us they will be removing their inmates from our facility, and some already have. That is 6 years worth of building a program to benefit the taxpayers of Clark County gone. Without the revenue, Clark County will foot the entire bill for the detention center. The substitution budget given by this court estimates that the cost of operations for fiscal year ending June 30, 2021 will be $2.21 million. In addition, the inmate community work program will cease because we will not have the adequate staff to operate. That is another $545,000 the taxpayers are out of pocket. So now the direct cost of the taxpayers will be $2.76 million. The magistrates who authored this substitution budget can explain to the taxpayers how this makes good economic sense. How is going from paying a net cost of $351,000 to paying $2.76 million, nearly 8 times more, a good thing? My staff has even run an economic model of doing away with the jail and paying other counties to house our inmates. We receive $35 per day per inmate, so you can assume that we will now start paying that amount. On average, we house 60 to 80 county inmates per day. In 365 days, the cost to the taxpayers could be over $1 million. But it does not end there. We still have the cost of medical, transportation of inmates to court, doctors, hospitals, and other expenditures, which when combined will be many times more than the $351,000 the taxpayers are now having to pay. Thank you again for this opportunity to speak and provide the public with the facts and the figures for the operation of the Clark County Detention Center.
Okay. Thank you, Judge, for allowing us to do that.
No problem. So motion has been made and seconded. Is there any further discussion? Frank, can you move your screen off? I can't see everybody. There you go. All right, motion has been made and seconded. Seeing no further discussion, all those in favor respond by saying aye.
Aye.
Aye. Those opposed? Okay, that motion carries.
There you go.
Now we have item number 20. Consider approval of an order to transfer funds from the road department funds to the road fund, Clark County, or road fund Clark Fiscal Court account. Do we have a motion?
Motion to approve.
Is there a second?
Second.
Any discussion?
Judge, I picked up a hard copy of the email today and I didn't have that in my packet.
Is Janet next to you, Michelle?
Yes.
Robert's concerned.
I thought I put it in there. I'm sorry. Did you have the one on the jail fund?
Neither one of them. I can look at the packet I printed out the other day, but I didn't bring it with me in here tonight. But it wasn't in the one I picked up today. I thought I substituted all the correct papers, but I didn't have that one in this new packet.
And then for the road department, what that's doing is on July 1st, it's just taking it out of the commingled funds, and so that'll be deposited in on July 1st in case any payroll or anything electronic.
I think I did have that in the one I printed out from the email. I think I did. I just didn't move it to this new packet.
And so all that 100,000 it's just an estimate of what the carryover is going to be. So we'll end up having to do another order at our first meeting in July to get the remaining amount over that.
Yeah, I got those in the one I printed out. This just one in the one I picked up today.
Okay. Janet, if you could, try to make sure all those things are included in Robert's printed packets. Thank you. Is there a motion?
I think we already had a motion, didn't we?
Okay, I may have missed it. Magistrate Constantopoulos.
Do we have a motion on the floor in a second?
Davis.
Gotcha. Okay, as Daniel said, this is simply to have operating money in a separate bank account for the fund on the first day of the fiscal year. Any further discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? That motion carries. Item number 21 is a similar motion. Consider approval of an order to transfer funds to the jail fund, Clark Fiscal Court account.
Motion to approve.
Is there a second?
Second.
Any discussion?
Just to clarify, just for everybody to know, that's for the same thing, the account, but that's going to be coming out of the transfer funds, which we made earlier, the cash into the receipt. So we've already budgeted for that with the approved budget.
Okay. Any further discussion? Seeing none, all those in favor respond by saying aye.
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 Any opposed? That motion also carries. Item 22, consider acceptance of an agreement between Detroit Salt Company and Clark County to supply road salt for inclement weather. Do I have a motion?
Motion to approve.
Second.
Motion's been made and seconded. Any discussion? Seeing none, all those in favor respond by saying aye.
Aye.
Aye. Any opposed? And that motion carries.
That was Constantopoulos and Davis, correct?
Is that correct?
Correct.
Yes.
Okay,
Okay.
thank you.
All right, now we have magistrate comments, starting with Magistrate Davis.
Judge, just want to thank those that presented today, particularly the folks that came and talked on the issue of solar farms. I know this is going to be an issue that we'll have a lot of discussion for and back and forth in the weeks and probably months to come. It appears to be a very long process, not just at the county level, but there's evidently a lot of state and federal licensing and regulatory approval that has to take place. But I trust that Planning and Zoning Committee or the commission and also the staff will do the best they can to give the issue a fair hearing and hopefully a public hearing, and we'll get to see an answer for these folks that are trying to invest money, and whether that's decision up or down. And also, Judge, just a minor note, I had a question today raised about mowing in the right of way on US 60, going from Clark to Fayette County. Obviously, that's state road right of way, but the issue was posed to me, and I think at least one or two other elected officials. And my understanding is that when I'm told, I think the contractor that the state is using has changed of late, or at least within the last several months. There was one pass made, so to speak, with the mowing, but I'm told that within about a month or so, there'll be a second full mowing in the right of way. So obviously we have a lot of people that travel that road and live and do business on US 60 and in that vicinity. So there's some concern, but it's something, Judge, maybe we can follow up on in the next month or so. If no more mowing has occurred, we can either talk with District 7 or somebody in Frankfurt about that, but hopefully it will occur. So that's all I had at this time, Judge.
Thank you. Magistrate Thompson.
I just have a request for you, Judge. Over the last several weeks, I've received, I think, around 10 complaints from residents of Open Station Road on the condition of the roadway. And I'd like to ask if you could direct the road supervisor out there to specifically look at the shoulder falling off in a couple of areas and some chug holes in the road. The other complaint that they raised with me was the amount of mowing that was getting done on the side of the road. Apparently, it is less than what has been done in the past. So if you could look into that and get back with me, I would greatly appreciate it.
That's Elkin Station, correct?
Yes, sir, it is.
Okay. Magistrate Constantopoulos.
Just a question to you, Judge. I guess on July, are we going back to in-person meetings? Is that the plan?
That is the plan. Of course, I will just note that the COVID-19 numbers appear to be increasing in the state and nationwide, and I can't promise you that the governor may not change his orders. But the plan is to be back in the fiscal courtroom for the next regularly scheduled meeting.
Good deal. All right, nothing further, Judge.
Robert?
Yes, Judge, a couple things. I I noticed in our email packet, there was a memo from Addie Wills at the animal shelter with regards to holidays for the rest of the remaining year in
Mhm.
administrative code. Is there some reason that wasn't included, or have you talked with her, or what's the status of that?
No, that's on my list of notes for when we revise the administrative code.
It wasn't mentioned. I just didn't want it to fall through the cracks.
Okay.
Let's see, I've got a few more notes here. Just one second. With regards to the courthouse exterior, since we will have some money, I took the liberty of contacting Buster Tucker. He is an individual with Casey Creek Construction, whom came highly recommended from the architect of the tower. I think I submitted and forwarded his contact information to you last April. I talked with him a few days ago. He's currently working on the historic buildings at Berea College. He would, if depending on what we have to do about the bid process. I know Frankie bid that last fall. If we didn't get it, I don't know if he didn't see it or what, but nonetheless, he does have availability to start in September, if we so choose to do that. So I don't know what we need to do to follow up on that, but since we do have the unexpected cash, and ironically enough, as I recall from my discussions with him, that number that we got for the tax credits is pretty close to what he estimated the repairs would be to the exterior of the courthouse. So what do we need to do to follow up on that?
We just need to check with the county attorney as to whether or not we are required over the $30,000 amount to do another bid process, or if this particular project would be similar enough in nature. And I suppose the last bid process would be recent enough for us to move ahead outside of that bid process. So we'll ask the county attorney that question.
Could we go ahead and move on this since we have the time to do it and he is available to do it for us? And since we didn't have anyone else express any interest in that project, could we try to have that on the next agenda?
If it's possible, I don't have a problem with that on the next agenda, but I have to check with the county attorney first.
Okay. And I won't mention Cook Avenue tonight.
Okay. Masha Graham?
Nothing further. Thank you.
Thank you. Masha Elkins?
Judge, I would only say that I want to thank the Bluegrass Area Development District for hosting these Zoom meetings, and very much appreciate them doing that, although I hope this is the last one. Look forward to getting back to meeting in person. But I didn't want to break away from that without saying thank you to Bluegrass Area Development District for the work they've done on the Zoom meetings. Very much appreciated. Thank you, Judge.
Thank you. Tab, I believe that Treasurer Champ would like to speak to the group. If you could allow her. Okay, go ahead. I can't hear you. Is she muted, Tab?
No, she is not.
Still can't hear you.
Judge, the county attorney was out, and so he asked Shay to come here because she didn't have a computer, and she was trying to do it through another computer and found out. So there you go.
Okay.
I would like to inform the fiscal court that I am withdrawing my name from consideration of being permanently appointed for the remainder of the unexpired treasurer's term. My husband has accepted a position that will better my family and require us to relocate to Northern Kentucky. My last day as interim treasurer will be July 15th, 2020. I want to thank the fiscal court for the opportunity to serve as your interim treasurer. It has been a pleasure working with each of you, and I wish nothing but the best. Thank you.
Thank you, Treasurer Champ. Certainly, I know that you said your husband has received an opportunity you can't pass up in Cincinnati, and I understand that's too far away to drive back and forth. Thank you for what you've done. You stepped in at a difficult time, and thank you for being willing to stay until July 15th, which will give us some time to perhaps open up more of a search. to that end, I thought it might be a good idea to, and obviously this is a fiscal court appointment. This isn't a county judge appointment. So I'm just gonna make a suggestion. If y'all don't like it, feel free to go with something different. But I thought maybe committee consisting of myself and Robert and Magistrate Elkins might be good. Simply because Daniel is involved in so many committees, it's not funny. And I haven't really had the opportunity to serve with Robert on much of anything. But if you all don't like that, we can do something different. But if someone would like to make a motion to that regard, I'll accept it.
I'll make that motion.
Second.
Okay, a motion has been made and seconded to form a committee to search for either interim or permanent treasurer consisting of myself, Magistrate Elkins, and Magistrate Blanton. Any discussion?
Judge, I will just amend my motion to say order. So there will be an order for that.
Okay. Any further discussion? Seeing none, all those in favor respond by saying aye. Aye. Any opposed? That motion carries. Let's see, I did want to update you all on US 60 because we kind of had to rush and vote at the last meeting. Unfortunately, WMU had some questions about the water and how it was going to affect their arrangement with Kentucky American. And that's kind of thrown off our schedule for one phase of the funding, which is CDBG. Basically, we're not sure we're going to make it in for CDBG this year. However, we do think that some of the other funding opportunities we will be able to get in for this year's round of funding. So we've been advised by the development district to keep moving the way that we are moving. We had a meeting the other day with Daniel, and unfortunately Magistrate Davis wasn't able to attend, but is there anything you'd like to add on that, Daniel? No? Okay.
Judge, I have a thought for you possibly on the US 60 project.
Sure.
I know last meeting we allocated some $9,400 for Palmer Engineering from fiscal court funds. I was wondering if it's possible that the benefited property owners would be willing to participate with some of these upfront costs so that the court don't have to go out and expend all the funds, assuming we may get reimbursed. I mean, if they're going to benefit from it, so it seems, I don't know why we couldn't ask them if they would like to participate in some of these upfront costs and lessen the burden on the county and the county taxpayers.
Well, to answer that to a certain degree, what we have decided to do because of the CDBG funds is to piecemeal the project. Where it currently stands is there's a bore under the interstate attempting to get the sewer line closer to US 60. The individual you're speaking about, who is a developer, is actually further on down US 60. What we've been advised to do by the development district is to just kind of complete the first part of it. And actually, what we may be able to do down the line is complete the part that will benefit the public at large, so to speak, that potentially being some of the neighborhoods along the Clintonville Road route, and then have the developer, if he so wishes, perhaps fully fund his own section at the end. Of course, that'll be up to the court to decide. But the way we've currently got it structured under the advisement of the development district is actually to the first part of the project simply benefit the public and really wouldn't involve that developer at all at this point.
Just trying to lessen the burden on the taxpayers.
I understand.
And just to reiterate to that, Judge, just for clarification, because one of the biggest parts of it is upgrading that pump station that's currently out there. So that would be basically redone to be able to eventually at some point, maybe not even of our lifetime, if that ever expands, where it could expand out to, correct me if I misspoke, basically cover the whole Hancock Creek watershed. So it would be already designed and ready for the flow of that as it progressed. So it's a good starting point to get that development moving out that way.
And that's all I had on US 60. I've taken your all's notes for mowing and shoulder work and also the administrative code. So with that all being said, I guess, is there a motion to adjourn the meeting?
So moved.
Is there a second?
Second.
Any discussion? Seeing none, all those in favor respond by saying aye. Aye.
Aye.
Any opposed? Motion carries. I've got 9:08 p.m. Have a good night, everybody.
Thank you, Judge.
Thank you.
Thank you.